ladies and gentlemen, to the, what's today? September 13th. September 13th, Policy Committee meeting. We have a very full agenda today, so we'll jump right in. I will call the roll. Ms. Craybill? Here. Mr. Wildebohr?
Present.
And I am here. A quorum is present. The next item on our agenda is the approval of the agenda. Do I hear a motion to approve?
So moved.
Motion, is there a second?
Second.
Any discussion?
I wanted to add a brief item before we get rolling to talk about progress going forward.
Okay.
It'll take like 2 minutes.
Is there a second?
Second.
Okay. Any discussion? All those in favor of the amendment say aye.
Aye.
Any opposed? Amendment is agreed to. Now I will ask for approval of the agenda as amended.
So moved.
There's a motion. Is there a second?
Second.
Any further discussion? The agenda is approved. The next item on our agenda is approval of the minutes. Do I hear a motion to approve the minutes?
So moved.
There's a motion. Is there a second? I will second. All those in favor say aye.
Aye.
Any opposed? The motion is approved. Before we begin Ms. Craybill's discussion, I'd like to recognize Mr. Lewis, who is joining us as our NC Papa representative. Thank you very much for joining us, sir.
Thank you.
Ms. Craybill, you are next on the agenda.
Yeah, all I wanted to, as we were going through our cleanup table and a number of policies that we've, like in this pile that we're going to be talking about, we have recently just amended those, but we didn't amend them with the amendments that NCSBA had. And so I just wanted to suggest to us that perhaps we go back just temporarily to a 3-hour meeting. And I know that's a pain in the butt, but there are a lot of them on here that we are behind on. We haven't gone through March 2021 and September 2021. And we are required to get updates, well not required, we get updates in March and in September from the NCSBA. So we spent a lot of time going through all the initials, and now we've got, you know, this big 255-page backlog of amendments. And even though some of the amendments are just one line, some of the policies are ones that we probably do maybe need to revisit. And I only brought that up because as I was reading through some of these, I was noticing that some of the policies that we have aren't even updated in Assembly. So I think we need to do something.
Are we suggesting to extend this one or the next one?
The next one, because it's not good practice to extend right in the middle of a meeting when people have planned their days.
Ms. Joy, could we please extend our meeting time next month for 3 hours, please? Not for 3 hours, but 2 3 hours. 5-hour meeting would be arduous at best. Okay, thank you very much.
I appreciate it.
Yes, moving on, policy updates. We will go through our individual policy updates before we get to the updates from the North Carolina School Boards Association. First up on our agenda is policy 1725-4035-7236, Title IX sexual harassment definitions. I know there were some questions about this policy from the board. Mr. Lewis has offered his time to go ahead and explain the thinking.
Mr. Jarrell Lewis.
Mr. Jarrell Lewis,
Yeah.
sorry. Has offered his services. Mr. Lewis, I'll begin with you, please.
Yes, thank you. So currently, 1725 is the policy that we use for the definitions under Title IX. Currently, the fondling definition, which is what the questions are regarding, speaks to contact that is underneath the clothing currently. Ms. Joy, can you show the slideshow? Or the slide? So I think it would be helpful for everyone to get an idea of what happens under the current definition. So anytime we receive a report of unwelcome touching underneath the clothing that is for sexual gratification, we consider that to be a report. What happens next is we do an intake process. What that looks like is the Title IX office, the investigator, goes out and speaks with the complainant or the victim and offers them various services, one of which includes the opportunity to file a formal complaint. For example, if the complainant does file the formal complaint, what happens next is that we do a pre-investigation / investigation to determine whether the allegation meets the definition of Title IX fondling. And from there, the decision is made when it is a student that is accused. The decision maker is Julie Barnum, Assistant Superintendent of Student Support. And then from there, it can be appealed to the board. I will say in this process, the Title IX regulations are very specific about what must occur during this Title IX investigation process, such as notices, written notices must be sent to parties for various stages. Parties are able to see the evidence. Parties are able to see the investigator's written report, as well as the decision maker's written report. All of this process can take up to 120 days. Most of them are shorter. Some of them have been longer than 120 days, depending on how many people are involved, how many complainants, how many witnesses. So that it factors on a case-by-case setting. So this is essentially what happens after there has been a report of Title IX fondling currently underneath the clothing. So if the definition were to be changed to underneath or over the clothing, we would follow the same process to resolve those complaints under Title IX. That would require us to do some different things. Currently, we manage the Title IX caseload through myself and investigator Mr. John Henry. If the definition were to change, we would not be able to resolve all those cases from the central office, Title IX office. That would require me to have to pass that work on to the school level to perform those type of investigations. Again, the Title IX regulations are very specific. Each individual role in the Title IX process, there's an investigator, there's a decision maker, and there's an appellate decision maker. All of those roles have to be specifically trained under Title IX. Because the Title IX office has been doing all of these investigations, I have not trained school personnel to perform these roles. So if the definition is changed to over the clothing, we will not be able to process all those cases from central office. Therefore, we will have to pass it to the school and have to train those individuals to be able to be the investigator and the decision maker. The appeal would still go to the board to be able to resolve those type of complaints. So I just want to provide that overview very quickly and open it up to questions if that's
Mr. Lewis, I have a quick question here. It sounds to me, if I'm hearing you correctly, that changing the definition to over the clothing, well, it might appear to be, and it's a stricter definition. It seems, based on what I'm hearing from you, is that, things that occur on an almost hourly basis in our elementary schools, wedgies, right? I mean, all the things that we know little kids do that are serious but are dealt with, that those become Title IX issues. And, I mean, it sounds like maybe that would take away from our more serious Title IX, not that they're not all serious, but Title IX as it was intended. I mean, am I hearing that correctly?
Right. So if this definition were to be changed to over the clothing, fondling would immediately become the #1 report that we have to resolve by a landslide. So with that, Title IX is essentially a civil rights law. What that means is that under Title IX, our role is to ensure that sexual harassment, that's what we're talking about right now, specifically fondling, does not become a barrier to a child's education. That's essentially what Title IX is about. But however, the regulations under Title IX say this specifically. Not every offensive comment, not every offensive act will rise to the level of Title IX. So the definition right now appropriately, separates the general offensive conduct that happens that we still have to capture through other policies, and those ones that have the potential to become barriers to education. And so there are other policies that apply. Title IX is just that first line of defense. For example, policy 4329, the bullying and harassment prohibited policy, talks about offensive touching, which this could come under. Unwelcome touching that has sexual connotations or is of sexual nature. That's specifically what fondling is about. And under those other policies, those things could be resolved in a manner that most people would think student conduct is resolved at the school level in a much faster timeline. In addition to that, we also have the disruptive behavior policy that captures the same type of behavior as well.
Thank you. Committee members?
Mr. Chair? Just a quick question, and maybe you can help everyone to understand. Say, for instance, we had a situation that happened at one of the local schools. So say it happened at Dr. Lewis's school, and the report was brought to him. At what point does he have to turn it over to you and can't handle it at the school level?
Immediately. So we have other policies that speak to that. I forgot the name of it at this point. But what happens is we tell the principal to put it in Ethics 360. In addition to that, Dr. Lewis knows, they give a call to us. And so that way what we're doing from the Title IX office and central office is determining if the allegation is true, would it rise to the level of something like a potential barrier to education that we would resolve. And so what I'm doing is determining, does it fit under Title IX policy or does it fit under bullying, harassment, disruptive behavior? If it's Title IX, then we take it. And then if it's not, and it's disruptive behavior or bullying, harassment, then we kick it back to a referral to the school.
Okay.
But they call us immediately so we can make that analysis and that determination. That's not what the principal's role is.
Well, if I could just follow up with one quick question. So, our chairperson made the comment of a wedgie. So there's a child that comes up to the principal and says, hey, somebody just gave me a wedgie, which would be kind of, to my thought, it'd be under the clothes because it's the person's underwear. So basically you're saying immediately he's got to call you, or can that principal, he or she, take care of it at that level?
Anytime there's some type of potential sexual harassment, we assume that what the report is true, and if it could be Title IX sexual harassment, they have to call us. So so we receive calls all of the time, and majority of our work in the Title IX office as the investigator involves having those conversations with school personnel to determine, is this something that we're going to take from the Title IX office, or is this something that's going to be referred back to the school to resolve under some other student code of conduct? But those calls are frequent.
Ms. Gribble?
Okay, so a couple questions around that. Does under the clothing mean like skin to skin, or does under the clothing mean the example that Mr. Wildebohr just gave, that I touch another kid's underwear?
It literally means under the first level of clothing.
Under the first level.
So if someone was performing a wedgie and the report was that while performing a wedgie, some of my body part was touched underneath the clothing, then that would be considered Title IX fondling from the outset. We would perform this process here, and if at the end we determined that the wedgie was not necessary for sexual gratification, we would then refer it back to the school to handle under some other student code of conduct. So it might start in Title IX process because we have to do that due diligence to determine, is it one of these Title IX issues, but at the end of the day, once we do that review, it could easily be kicked back to the school.
And so,
I'm sorry.
yeah, no, jump in, please.
Well, also though, when that happens, the school we wait. And so that sometimes, that Title IX process, because it's serious, while we wait for them and they're really busy, we can't necessarily assess discipline, right? So as a school principal, like a wedgie, okay, that's discipline, that's pretty easy. But if we go to Title IX, and then we have to put in some factors to try to do the best we can for all those students involved and notify them, because they have rights once the Title IX process starts, like Mr. Lewis was saying, and that puts us on pause. So it does present a difficult position sometimes for the schools.
Sure.
And I will add to that, thank you, Dr. Lewis.
Yeah.
The reason for that is because they're under the Title IX regulations that we currently have at the federal level, not at the New Hanover County School level. At the federal level, they are they were built with the specific intention of providing due process rights to the accused students. So therefore, we cannot treat them as if they are guilty or responsible until we get to the very end of this Title IX timeline, which could take up to 120 days or longer, depending on each case. So there is some frustration and disconnect at the school level because complainants are seeing this, saying, I reported this a month ago, why is the student still here? Because we haven't finished our Title IX investigation process, and we have to treat the person as not responsible until the resolution under this Title IX process.
Ms. Gribble?
Yeah, so the two things that I want to add. First, along those same lines, is I was just at a school justice partnership meeting this past week, and the example that Ben David gave to us was exactly what Mr. Lewis, are you Mr. or Dr.?
Either's fine.
Okay, I'm not gonna call you the right thing,
Yeah.
the chief.
Doctor's fine, Miss.
Thank you. So the example they gave is, in the school justice partnership, is if we charge this kid, and then we're basically saying to them, something has happened, we're gonna talk to you in 6 months, because that's how long it takes. And that the court system, Judge Corpening agrees with this as well, is that if we can handle everything as close to the time of incident as possible, with the highest level of authority at that level, then we will get more bang for our buck, so to speak, on changing behavior. So we're not having to wait. So I did want to bring that up because that was a very compelling point in the school justice partnership to keep our kids out of jail. So then the second thing is, would you please just explain to us again that this definition, this R, is part of the law, and that we should have probably, when we adopted this policy in the first place, should have done the R then. And so we are really not at liberty, if I understand correctly, to do a lot of changing to the definitions, because these are the federal definitions. So if we don't change fondling, could we add a letter E that says something like unwelcome touching? Just to add that one last thing in there, perhaps. That would include the over the clothing. I don't know if that would help or if that would just add one more layer. But
So the Title IX regulations from the Department of Education, they have provided us the specific definitions that we must follow. They provided a little wiggle room. For example, under fondling, we can determine whether it's over or under the clothing. The definition of consent, individual school districts can decide what that definition is. But outside of that, the definitions are very specific. And so with any regulation, any law, at the federal level, that is setting the floor. At the very minimum, we have to capture this behavior under Title IX. We can always add to it and put whatever in addition to that floor underneath in our Title IX process, but we can't go lower than that floor, which means we can't change these definitions in a certain way that modifies what the regulation states. But specifically to fondling, we can change what a private body part includes, which would be underneath or over clothing. The last part you said, including a sense of touching and things like that, I would remind you that policy 4329 specifically says a sense of touching, specifically mentions unwelcome touching that has sexual connotations. So it's like multiple layers of policies that apply. If after Title IX is done, it goes to the next level at the school. And so this behavior is still captured in the student code of conduct. Whether it's considered Title IX or just student code of conduct is what would be the question to determine.
Mr. Littlemore, last comment?
Okay, well, and not comment, but question. I think that what I'm hearing, you've made the comment that we have a concern that your office will not be able to handle if we change this, and it would be kicked back to the school. My way of thinking, if I was a parent, I would be saying that's great because they're the ones in the school that they can handle it. So, honestly, I think that as much as we can handle it, to Ms. Craybill's point, I think as much as we can handle it at the school level, I think that's great, because I think that also, my biggest concern, we've had discussions, actually 3 of us have had that discussion, my biggest concern with this whole process is, as you said, it could take up to 120 days, and if a child is innocent, well, great, that he's got 120 or she's got 120 days of innocence, but if they're guilty, and we've all heard from at least one parent that has had a lot of concerns about the fact that my child is being, subjected to this child that has done something inappropriate to my child day after day after day after day. And, and I understand. So I think the quicker we've changed the policy a little bit too, so we can hopefully speed this up a little bit. But, I think that, which is great, but I think that the overarching thing here is the faster we can get it done. And I think the investigation at the school level, to me, it makes a lot more sense. That maybe they haven't been trained specifically in Title IX, but as an administrator, I know I was trained to do investigations. I'm sure that all our principals and assistant principals have been trained to do investigations, and I think that would be a more streamlined version and a better way to do it. So,
I would just point. So if by changing the definition to over or underneath the clothing, that would require Title IX office to send more cases back to the school. But they still have to follow the federal regulations.
That would be
So it would not speed up resolution of complaints, it would essentially just change the venue. Who is going to resolve it? Instead of central office, it would be resolved at the school.
It would
But
actually
principals
increase
still have
more.
to.
I was gonna say, that sounds like it would
Yeah,
really
and so
increase.
we'd be waiting, because if we put it under Title IX and we make it that federal policy, then we are constrained by the same things that are constraining Mr. Lewis. And so we would actually increase the amount of cases that we'd have to wait longer before we could assess discipline.
So instead of just resolving a discipline issue, you'd have to
Right,
go through the
because
process.
now I'd be bound just like his office is bound. So I would, instead of, I think last year I had a handful of cases, which, we had to make some arrangements for. I could potentially have 6 cases in a week that I'm having to maybe redo schedules, change things, move people around because I can't assess discipline until that process is complete, and they have rights to do stuff in writing and reply to one another in writing. I have to wait on all that for the party. So it would actually, I think it would go the opposite way and increase our time.
Mr. Chair, can I weigh in briefly and ask
please.
Mr. Lewis a couple
Whoever
questions?
said that, was that Colin?
Yes.
Okay. Can we see his face?
Yeah.
Hang on, Colin, we're waiting for your face. Okay,
All right. Sorry to jump in.
that's all right. Speak loud,
Okay, can you hear me?
barely.
Yes, sir.
Barely?
Yeah, you're very soft.
My volume's all the way up.
Okay.
So it might be there.
I think Anita's going to
Anita's going to
see
check.
if we can turn them up.
Okay. So, Mr. Lewis, if you can hear me, just to reiterate and kind of clarify for everybody in the public, even if the definition stays as it is, that fondling is under the clothing touching only, if there is an inappropriate over-the-clothes touching that occurs at a school, that can still be addressed and would still be addressed under other school board policies and could result in discipline for that student. Is that correct?
Correct.
And isn't it also the case that if the definition stays the same as it is now, and there was maybe a pattern of over-the-clothes touching or an over-the-clothes touching incident that was so serious in nature so as to interfere with the student's access to the education system, that could amount to sexual harassment, even if it didn't meet the definition of fondling?
Yeah, so that was my last point, but the question didn't allow me to get there yet. So Title IX can still capture behavior that involves offensive touching no matter where it occurs, over or underneath the clothing. That would be captured through our Davis standard definition, which essentially says there's unwelcome conduct of a sexual nature that is so severe, pervasive, and objectively offensive that it effectively denies equal access to education, talking about that barrier. So that can look like incidents that are a pattern. Maybe there was 3 or 4 different individuals that said they were touched. Or maybe this person has done this for multiple years in a row. And that changes it from just a one-time fondling to a more, to an incident that could cause a barrier due to the repetition and the pattern. And that would be captured under Title IX Davis standard definition. So that still allows for a certain level of touching offenses to still come under Title IX, depending on each case.
My last question, Mr. Lewis. If the definition was changed to include over-the-clothes touching, if on a school bus, a student is getting off the bus and brushes against a female student's chest and that student complains about that, then we would have to treat that as a Title IX offense that would then be subject to the 120-day deadline, all the due process rights that come under the federal regulations. Is that correct?
That's correct, because we're assuming the allegation as true. We can't just kick it out from the very beginning. We have to go through that process.
Thank you. That's all I have.
I just want to clarify for the people who are listening, that just because a principal from years ago had training on how to deal with some things, the laws have changed dramatically over the years, and we did have principals that probably were trained way back in the day, and we still had issues. So I just want to reiterate that anything we do Principals and APs will need to have the appropriate training provided by Mr. Lewis, which he is doing, for a lot of different things, that we can't just dump this on the principals and say, we gave you training around that. So I want to just, because that's what people are just worried about, is that our principals aren't going to do the right thing. And it's not because they don't want to do the right thing, it's because either they weren't trained appropriately or they have just not had enough practice.
Yeah, and so the principals have been trained. The training that the principals currently and historically have received since I've been here has been about the reporting process, such as, the report comes to school, Dr. Lewis knows just enough to know what to do to get to the central office. There are specific roles under the Title IX process: the investigator role, the Title IX coordinator role, the decision maker role, and the appellate decision maker role. Those roles are specifically outlined in the Title IX regulations at the federal level. The regulation also specifically says that those investigator, Title IX coordinator, decision maker, appellate decision maker must be trained, and it tells us specifically what they must be trained on. Principals have not received that training because they currently do not have a role in the Title IX resolution process, this timeline here. If the definition were changed, I would immediately have to train the principals because the Title IX office is not going to be able to manage that high volume of cases. So that would be the step number one, is to train them specifically in the role as the investigator and the role as the decision maker, which would then be removed from Julie Barnum's role.
Mr. Lewis, thank you very much for giving us a real clear definition and a real clear timeline of how all this might look. I appreciate it. I was concerned at the board meeting, this is why I asked for this discussion. But hearing your reasoning and trusting your expertise, of course, I will move that we pass this policy back to the board. And I'd also
This is not a
ask,
policy, it's a regulation, just so we
that
know.
we pass the regulation back to the board as is, without changing the definition of fondling.
I second.
There's a first and a second. Any further discussion? Okay. So, Ms. Craybill, how do you vote?
Yes.
Mr. Wildebohr, how do you vote?
Yes.
And I will also vote yes. That policy will be moved on for second read, that regulation
So where's it go?
will be
Under this
moved
one?
on for second reading. Yes.
Okay.
Okay, the next policy up for consideration by the board is policy 2120, Code of Ethics for School Board Members. This was an amendment to policy 2120 that I have been interested in a long time. As everyone knows, there has been, I think, nationwide, certainly statewide and also countywide, for an increase in transparency and increase in trust from all of our local governing entities. And in that vein, and as we're coming up to the end of a term, I proposed the following amendment, adding section C to policy 2120. I'll go ahead and read that for you. The Board of Education recognizes that election to the board is a service and that the office should never be seen as a tool or mechanism for personal gain. Therefore, it will be the policy of the Board of Education to refuse consideration of former board members for employment in any administrative position for a period of 2 years after the expiration of a board member's term. Furthermore, New Hanover County Schools will not enter into any new contract with any organization to which a former board member has a personal, financial, or professional interest for a period of 2 years from the date of separation of said member. This timeline is in keeping with the timeline established by our county commissioners when the endowment was created. So no commissioner can get onto that board within 2 years after the expiration of their term. And it's not about anything concrete, it's about the appearance of what may be, and I want to protect the New Hanover County Board of Education from any possible appearance of conflict. So that was my thinking behind it, and I'll open it up for discussion.
Mr. Chair, if I could.
Mr.
First of all, I have to ask what you and I have talked about this back months ago with a slightly different definition is now changed to administrative position. Before we talked about even substitutes. My first question is really what's the purpose of this? And secondly is that, my litmus test, my line in the sand is how will this improve the education for our students? I don't see the real need for this in any form or fashion. I think of things, I trust Dr. Barnes and his staff to hire the very best person, whoever that person may be. And I would hate to see a situation that if there's a need, say for instance, an interim position comes up, they reach out to a person and say, hey, we really need this person who has expertise in this area to come in, fill a gap, and we say, oh, I can't do it for 2 years. I mean, you look at the state of North Carolina. The state of North Carolina says that a person who is retired can't come back in for 6 months. I think 2 years, I understand what you just said, but I don't think we need to follow everything that the county commissioners do. So I see a lot of concern with this policy.
So again, I think the point is, I don't think Dr. Barnes, I don't even know if you'd be allowed to consider the appearance of a conflict when making a hiring decision. But I don't want to put that on our administrative team. The reason I wanted this policy was just because we're coming up to the end of a term, and I think it's important that the public trust that we are doing this for the right reasons, and that creating a policy where even the appearance of gain from these positions is eliminated is a step that, I know you've been passionate about making sure that the public knows that we're doing these things for the right reasons. We're being as transparent as possible, and this policy is just another step in that process of regaining public trust.
Well, I think it's a very questionable step. I don't think it actually does that in any form or fashion. I think there's a lot more important things we could be doing to rebuild that trust than, say, an administrator or a person that's on the board. I mean, I just don't see. Have you had any have you heard of this happening in New Hanover County schools at all, ever? I mean, why? I just question.
I have heard often spoken a term in the county system of the good old boy network, and there's a perception that you have spoken to that it's a good old boy network. I don't like that perception. I have spent 4 years trying to make sure that people in our community know that that is not the case. To have an expiring board member go into an administrative position, I think would be a public relations disaster for this school system or any school system. And it's been something I've been passionate about for a long time, and because I just felt the time was right to bring it forward.
Mr. Chair, if I could ask one further question, and then I'll stop. Why the change? You had talked to me about this in June, and you had said any position. Now all of a sudden we're switching to only administrative positions. Why is that?
Well, I think your statement when I said that was, there's no reason somebody can't go back and teach. I don't think that would be seen as an advancement. I think going from a teacher to a principal to a position in central office after a stop on the board, that could be seen as using that position for advancement. So that was the reason for that. I don't see a real conflict with going back into the classroom if somebody wanted to do that.
I'd like to see if Mr. Shive has anything to add on that. I know this is something that general industry uses all the time. It's called a conflict, what's it called? I mean, I have to sign those all the time. Non-compete agreement, sort of. Is this kind of like that?
Well, I think it's obviously, it's a little bit different in that, it's a prohibition on somebody who's been in a political office going back and working for that entity after they leave service. So I think it's a little bit different than a non-compete, and we don't impose non-competes on our employees. So if your question is, do I have legal concerns about the policy? It's a novel policy. It's not one that I've seen before. I can't say that it's illegal. I think we want to articulate our justification for it. Perhaps in a praeses if the board were to adopt it. And I do think that if the board were to adopt it, we would want to make sure we carefully define administrative position.
Okay.
So I guess, you know, and talking about an appearance of conflict, you know, I just think that from the top to the bottom, if you look at people's concerns, I know there are plenty in your party who have some questions over Hunter Biden's laptop and his business dealings with Burisma. And those are good questions. Those are questions that should be asked, and that's not even the individual, that's a family member. We don't want people, I believe, to think that there's some sort of connection between our work on the board and our work outside of it. So again, that would be my justification for it. But I'd love to discuss it further as a full board. You know, I didn't want to devote too much time to it. Any other?
Well, I have two things on that. One, if we were to move it forward, I would suggest that we make it the same as a retiring person, that's 6 months. Because that would be in keeping with, you know, people who retire can't come back before 6 months, even to volunteer, you know, in the schools, which the volunteer thing blows my mind. But again, that's the law. So I would be interested in entertaining that.
I would entertain that for the first part. For the second part, that would be, I mean, the not entering into a new contract. If somebody on this board goes into a, you know, a consulting role or goes into a role on a board of directors, and then the school system hires that company, that is problematic. When 4 of your buddies you were just working with 6 months ago, say, okay, well, we waited 6 months. No, that second one especially is really problematic.
Colin, can you weigh in on that?
I don't see, I mean, again, I don't necessarily see a legal concern with imposing a waiting period on contracting with the company for a period of time after a board member leaves service.
Okay. The other thing about, if you look at our cleanup table, it is, in addition to that, it's talking about some other things. So I think we need to look at those too. And it doesn't show up in the policy that we have a copy of, because B14 says the board members refrain from investigating or attempting to resolve complaints personally. Instead, they follow the grievance policy. So I'm not certain where we put in this policy, the wording, the reference to the reference that is from policy 2120, so 2121. So where do we add that? It doesn't make sense to put it under B14. We already have a B14, and then we would have to renumber all of that. So do you know anything about that, Colin?
No, in terms of, I mean, are you asking for my advice on where it would follow? And
No, I'm just wondering, because this is specifically what if Nelson hadn't brought up his amendment, this is what we would be looking at. The subsection B14 to reference do you have that, Kim, on the cleanup table? Or I'll just read it. To reference the new provision in policy 2121 stating that a board member will not influence any personnel matter pertaining to the board member's spouse's employment with the school system should be added to the policy only if the board adopts the policy in 2121. So I'm just wondering where if we were to adopt what 2121 says, which will be coming up in a little bit, where would we put it?
I haven't looked at that, but I'm happy to do so after today's meeting.
So then I would recommend that we not make a decision on that one until we talk about 2121 later, and then we figure, and maybe this is one we just have to hold. Because it does talk about and it also says later down that's a different policy, okay. So I just want to make sure that 2120 and 2121 go together, because they're talking about a different sort of conflict of interest.
Yeah, we can go ahead and discuss 2121 now and knock these out. That's fine. I'm fine, by the way, with making that 6 months after the expiration of a board member's term. Dr. Barnes?
I'm not sure if it's relevant or not, really, but Policy 7100, the recruitment selection of personnel, has a very clear process for ensuring that the best person's hired. I think Mr. Wildeborn mentioned that. I think something this board's done very well with is not pressuring a recommendation. You know, the school system makes a recommendation, but you're, as a board, actually the employer of the person. So my feeling would be, as long as there wasn't an influence to recommend the best person, then I think that the board policy 7100 should cover some of the things that are being addressed today. If that makes sense.
It does.
All right, so everybody got policy 2121 pulled up?
2120, yep. What'd you say?
All right, the policy revised the last sentence in the first numbered provision to clarify that a board member will not influence any personnel matter pertaining to the board member's spouse's employment with the school system. And it adds new conflict of interest rules for board members as required by state law. I didn't see anything of note, except that a board member will not solicit or receive personal financial gain from the school system by means of intimidation, undue influence. It's a new line that was put in there under general statute. But I didn't see anything of concern here that troubled me.
No, and I guess what I was getting at is some of what you, not exactly what you have proposed, but some of what you have proposed was covered in policy 2121. So as far as solicit or receive personal financial gain, and I would think.
That's for a board member, not a former board member.
Okay. Well, okay, so this is a current board member. But yet it says new conflict of interest laws for board members. Okay.
So the law, I don't know if, it's sort of a blank area, but I want our policy to be reflective of the will of the voters and of their mandate that we be as transparent as possible. So,
I'm fine with 2121 as presented
Okay.
to us. So therefore, I would be fine with inserting the appropriate wording into policy 2120 under B14, but we would have to, Colin might have to take a look at that and figure out where that fits in and that's for current board members.
okay, so I think we're fine with both of those. We're just going to need some help on the placement. I mean, I think B14 is fine. I don't see any problem with B14 being where it is.
Well, and maybe we just add it, to be, 22, would not have to renumber everything, but I would suggest that we go ahead and move the ethics, the 2120, change,
6 months?
include your wording, and change that to 6 months to be consistent with what, our employees are managing. And then we get Colin to help us with the wording on, and where we insert what is recommended to us by the NCSBA.
Okay, so
So
we'll take
I guess I
these,
moved that.
we'll take these separately.
Okay.
Then, does anybody have any problem with moving 2120 on? Are we doing first reading with these since there are substantial changes?
Okay, so we're going to get to that policy coming up, which we'll talk about, and we do not have to have a first reading and a second reading for policies that are being amended. We are allowed to just come from policy and take it to the dais
Yes.
and vote on it.
Yes, we
So
are.
I don't think we need to, that's coming up, and I forget which policy it's in. I think it's in the development of new policies. So that's coming up. So this would basically be sending it to the board to put on our agenda.
Okay, that's fine, 2121.
So which box are we gonna put that in? It shouldn't be policies for first reading, but it probably should go up in that box.
Yeah.
Policies to move to full board with the changes. And so that would be, Colin can help us with the wording.
That's fine, 1725.
That would be what I would propose, or motion that I would make, if however we have to do that.
Okay, and then, so there's a motion to pass 2121 as is. I will second. Is there any further discussion on 2121?
So 2121 is actually in the lower right quadrant. We are just moving it forward. Right?
Yep.
Okay. So, yes, that was 2121. We kind of jumped out of order a bit. So that's 2121.
We need to take a vote on that, don't we?
Yes. So there's a first and a second. Any further discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? On for amendment. On to the board for amendment. Policy.
Wait a minute, now 20?
Policy
2120.
2120 has
Okay.
been changed with language that stipulates that an employee will not be considered for an administrative position for a period of 6 months
A board member.
after the expiration of a board member's term. So, yeah, a board member, sorry. And then the second paragraph will stay the same.
Except not 2 years, it would be 6 months as well.
If you would like, I'd prefer to have that at 6. I mean, that's fine.
Well, I would prefer 6 months,
That's
but Mr. Wilbur should certainly weigh in.
That's fine.
I'm going to stay right where I have been the whole time. You know, to my knowledge, no, this has never come up in New Hanover County Schools. We've never hired, to my knowledge, a retired person that's retiring from the Board of Education. So
Good.
I don't think there's a need for this. So it really doesn't matter if it's 6 months or 2 years. I don't think either are applicable, acceptable. And like I say, I don't want to get into the politics of the whole thing, but I think, you know, and I'm not going to consult either of you by saying any more, so I'll just leave it at that. But I don't think there's a need for this policy.
Well, we've never done it, and the point of it is to make sure that we never do. We don't create that conflict of interest.
Well, I go back to even, say, a 40-year-old, and I said I wasn't going to say any more, but since you brought it back up, say a 40-year-old runs for the board, makes it, you know, is this not going to be a roadblock for that person at some point that, you know, an older person, you know, whatever, that they're probably not going to be going back into the whole mix anyway. Let's say there's a 40-year-old that runs for the board, and it has an opportunity after that person, he or she, gets off the board. I mean, this might be a roadblock, and I go back to what's the best thing for the students. I mean, I understand we put anything under transparency. Transparency, we all want to be more transparent. I don't know that we do that very well, but I think any step towards that would be profitable. I don't see this as a very big step in that direction, so. And I'm going to leave it at that.
Well, I will say, you said you weren't going to insult me, but I was 35 when I ran for the board, not
Okay, there you
not
go.
40, not 40.
All right, young man.
And I could use a 6-month break after 4 years.
All right.
Much love as I have for everybody here. All right.
And I would also like to just point out that our terms end in December, and so 6 months after that would be June. And so that would be the start of a new school year. So it really doesn't create, to me, any hardship of waiting and deciding and making sure that you have all the right credentials and blah, blah, blah. But, so, all right, so my motion still stands. My motion is to accept policy
As amended.
2120, that with Nelson's amendment from the wording, except changing from 2 years to 6 months, and also adding in the appropriate words that have been suggested to us from the NCSBA. That's my motion.
I second.
Okay.
So there's first and second. Any further discussion? All right, hearing none. Ms. Crable, how do you vote?
Yes.
Mr. Wildebohr, how do you vote?
No,
And I vote yes. Policy is moved to the board for amendment.
I'd like to make a motion that we don't move it to the board for amendment, but we do have a first and second reading to give everyone time to weigh in on it.
So Colin, it's my understanding that the board gets to make that call. The full board gets to make that call on first and second reading. Is that right?
So just to recap what just happened, so there was a motion to move the policy to the full board for a vote on amending the policy, correct?
Yes.
And so at this point, that action's been taken. I think that if when it gets to the board, you know, Mr. Wilbur or any other board member can make a motion that it go through, that it not be voted on or acted on until the next month's meeting. Otherwise, at this point, I think the way to, otherwise, at this point, I think we would need a motion to reconsider the action that the board just, the policy committee just took in sending it to the full board.
Well, I personally don't think it should be the position of this policy committee to dictate how the board hears our recommendations, so.
But if I could answer back to that or discuss that, I think that we just talked about transparency. And if we talk about transparency, then we should truly be transparent and, you know, give people, besides the board, an opportunity to weigh in and not just have a vote the first day. So I think in a situation like this where we have we don't have a 3-0 vote, I think that it does nothing but make us more transparent to be able to hear from additional folks and not just hear about it the first time and then vote on it.
Well, again, I mean, the
Okay,
board.
so Pete made a motion.
I made a motion.
I'm not seconding.
I'm not seconding it.
Okay,
Okay.
all right. Moving on. The next policy that we are going to discuss is going to be policy 2230, board meeting agenda. Ms. Crable.
Yes, so I brought this up basically so that we didn't have to keep bringing this up. That if you look at in letter A, the words that I am suggesting that we add is that the following agenda format is to be used as a template in preparation for board meetings and can be modified as needed for a more efficient meeting. Additional closed sessions may be added in the appropriate place. So I made a million, cross-outs trying to change the order, and then after and the reason I was doing that was I was trying to get student voice, added in there because it looks like we are going to be moving forward on that policy. And I wanted to make sure that we always had the student voice right up under recognitions. But if we are just using this as a template, then the order of go in the policy doesn't really matter. It's just basically stating the items that we want to make sure that we cover. And then just FYI, old business, new business, you don't necessarily even have to do that. It can be information items and action items. We don't have to do that. So that would be one thing that our board may want to discuss, because that just kind of adds one more layer of things. So that was that proposal in letter A. And then the next proposal, it's really not a proposal, in letter B, somehow the wording and the item will be added to an agenda within the next 2 regular meetings. We voted on that, and I'm sorry.
We did not.
Huh?
We did not. That's why that never got added. We didn't vote on it. The board decided from the dais at a meeting to do it.
Well, no, I understand that.
So,
Let
you gotta add that.
me rephrase. The entire board voted to add to, that the item will be added to the agenda within the next 2 regular meetings, and those words never made it to the policy. So this is really just a putting in something that we forgot to put in the first time. So that's really not a change, it's just adding it. So those are the 2 things that I had with this policy.
I'm fine with both of those changes. Mr. Wildebohr?
As am I.
Okay. I move that we adopt policy, or we move policy 2330 to the board for amendment.
Lower right corner, is that right?
I don't know, I'm just going, yeah, sure. 23, I'm making my own notes.
Well, no, I think we need to be clear on where we're putting it on this, because this is what Kim uses, to help us
Yes.
organize our thoughts.
So that is going, I'm putting it on the
Okay.
upper right box because there are changes to it.
Well, no, okay. But then the
That's just-
changes are what we proposed.
I'm just putting it in
Okay,
this box
wherever,
so I
okay.
can read it when we,
Okay,
yes, the proposed changes here, the adding that language is a change. Even though it's what we agree on, it's still a change.
okay.
All right. So 2330 is finished. We are on to our substantive changes from the North Carolina School Boards Association. We will go in order. The first policy up for discussion will be policy 1310. The change from the School Boards Association expands on the term sex in subsection B29 to add including pregnancy, childbirth, sexual orientation, and gender identity. Before we get into the bulk of the policy, I'd just ask, does anybody have a problem with that change from the School Board Association?
No.
Okay. It deletes a word in subsection D11 to align with policy 3225, technology responsible use. Did anybody have a problem with that?
No.
Okay. Mr. Wildebohr?
Yes, no, no, sir.
And it updates the cross-references. It's fine with all those updates. Does anybody have anything substantive to discuss on policy 1310?
Two things that came to mind. In the first paragraph, the last sentence where it said, the board also encourages parents to participate in activities designed by school personnel to involve them, such as parent conferences. And I was wondering if we want to put in there and parent information nights, because that is one of the key things that I think that schools really, they go to a lot of trouble to put on parent information nights, and it's a different format and a different level of comfort and a different everything when you're talking about your information nights, and we really want to encourage our parents to come to those kind of things.
Where are we putting that?
I'm suggesting in the last sentence of the first paragraph. And it's basically just adding another such as, because that, to me, is an important thing that schools want from their parents as far as involvement
I have no
versus
problem.
like just volunteering.
I have no problem with adding that. Does anybody see a problem? Excellent, okay. That
And
will
then-
go on, and parental information nights will be added to the last paragraph.
All right,
Or the
and
first
so
paragraph.
number six, sorry, where it says parental training, that to me just implies that we're trying to give training on how to parent. And so is parent training better than parental, or am I just reading too much into that? I just don't want parents to think that we are trying to tell them that they don't know how to parent. And,
I have no problem changing the parent training. I think, my thought either way is helping parents maybe understand what's going on in the school, but parent training is fine too. I probably would have used parent training instead of
yeah,
parental.
because it just seems more like engaging. I want to train you on how to use the
That's
one-to-one
fine.
device, okay?
That's fine.
Right.
All right, that's all I had in that one. And number 5, where it says involvement of parents and guardians in school decisions that affect children and families. So, did we want to have any such as is there, such as the school improvement team through parent surveys and that kind of thing, or do we want to just leave it?
I'm not a big such as.
Yeah, I think it states itself.
Okay, I'm good with that.
Okay, Mr. Wildebohr, did you have anything on 1310 that was different?
No, I thought that was, like I say, I definitely agree with Ms. Craybill's 2 comments there, but I think overall it's
We will move.
very, very good.
Thank you, sir. We will move 1310 on to the,
So we're
onto
going
the board
upper right,
for
correct?
amendment.
Upper right,
That's what I'm
yeah.
doing.
Right, okay, because there is changes.
All right. Moving on down the list, policy 1710, discrimination, harassment prohibited by federal law. The change that we have, the update from the School Boards Association is the same as in 1310. It's expansion on the definition, on the term sex to add including pregnancy, childbirth, et cetera, et cetera. So it's the exact same language definition. Mr. Shive, is this coming from state statute?
Federal.
Or maybe-
Sorry, I had trouble unmuting myself. I believe this is coming from federal Supreme Court case law.
Thank you, sir. I just wanted to know the nature for the change from the School Boards Association. Thank you very much. Does anybody have any questions on 1710 with regards to the policy change from the School Boards Association? Does anybody have anything substantive on 1710 other than outside of those changes? Okay, great. 1310 will be moved without changes.
1710.
1710, sorry. Some kind of 10. All right, moving on, moving down, moving forward, ever forward. We already moved 2120 and 2121 with changes. So that's good there. And now we will discuss, excuse me, 2210 duties of officers. Updates can be found to language in D6. This is optional changes. Anybody have anything?
I didn't unfortunately get the first page. I should have called out and asked for that, but I did not get page 1 of 3, page 90, 89, I guess it is.
Well, there were no changes there, but there's
Scroll down,
D6.
up so you can see the first page.
That's page 2 or 3.
Yeah, you can use my first page.
Oh,
I didn't have anything on page 1. Well,
Yeah. Okay, thanks.
Ms. Crable, Mr. Wildebohr, did y'all have anything on the optional language change to D6?
I am in favor of including the alternate, or the optional change. We're already doing it.
As am I. As am I.
We're talking about the, on D6, is correct?
D6,
yeah.
maintain board members' manuals of policies and administrative regulations in current status, or alternatively, ensure board members have effective access to current electronic version of the manuals.
Okay.
We're doing that, and
Yeah, I'm
hope
good.
we continue.
I'm good.
So we will move that forward without changes. 2210 to the board for amendment. The next policy that we will be discussing is policy 2302. This should be interesting. Remote participation in board meetings. Let me open this by saying that I do so enjoy a good remote participation every once in a while, as I'm sure you all must. But pandemic and time march on, so Section E clarifies that special rules in that section apply to remote meetings held during a declared emergency. And in subsection E2, it adds a new notice applicable during a declared emergency as required by a change to state law. E9 modifies the deadline for submitting written comments on a matter up for a public hearing in accordance with the change to state law. And there are updated legal references to reflect those changes. So does anybody have anything that they would like to discuss with regards to the changes from the School Boards Association?
I don't have anything to add as far as the changes, but I do note that we are going to have to make some changes in our accountability.
Indeed, Ms. Crable.
Especially in letter C. So, but I am in favor of all the changes that they did. And just to call to the attention of the general population is that we are not allowed to have anymore, now that we're not in a state of emergency, wholly remote meetings of the board. And that board members are only allowed to participate 3 times a year, calendar year. So from, I guess calendar is considered January to December, or is that considered July to like a school calendar year? What is that normal?
School calendar is
July to June. So do you think this means, Colin, a calendar year? Or does it mean like January to December? Or does it mean a school year?
It seems to be silent on it. I think you can define that yourself as you'd like.
Do we want to define that?
No, I think it's a calendar. A calendar year is a calendar year. A school year is a school year.
Okay, so calendar means January through
January to
December.
December.
Okay, so that is one of the things that, I just wanted folks to know that, and that a person who needs to participate remotely needs to let the board chair know
I
that they want to do that.
will be saving up my remotes for the summer.
Okay.
All right, Mr. Wildebohr, do you have anything on policy 2302?
No, I think it's good that it clearly defines exactly what's going on, so I think we need to move that on.
Okay, that will be moved on to the board for amendment without changes. All right, Board Policy 2400 is our next policy up for consideration. That policy adds a reference to policy waivers requested under 3430, School Improvement Plan, and adds policy 3430 to the legal references. It is recommended if our policy 3430 provides for such waivers. Is there any question from our committee members?
I wanted to wait to see if, until we talked about 3430, if our policy is allowing for those waivers. So, or if any of the senior staff knows that right now, because that's basically what it's asking us. So we can hold it and come back after we talk about 3430, because that is also on our
Sure.
list.
That's fine. We'll just, or unless
I mean,
somebody can
Dr.
answer.
Faust or Julie or Patrice, if she's on.
Yeah, it would be more of a Dr. Faison question,
Yeah.
but I'm happy to support her in that, if she's not here.
Well, whenever you get an answer, just, if you could let us know, thank you.
Well, I mean, do we want to hold that?
Yeah,
Let's hold that one.
We'll hold that.
Okay. And then I did have another question, just so we can get that out, Julie, maybe you can ask too. In the first paragraph, the last sentence, where it says, all policy decisions will be made while keeping in mind the board's objective to provide, and I wanted to add the word all students with the opportunity to receive a sound basic education. Sometimes I think we struggle with the all.
Which paragraph are you
It's the first paragraph, the last sentence.
in? 3430?
No, I'm sorry, 2400, the one that we're still in, that we held before we completely
Sorry.
put it on the table.
I already moved, I moved on.
I know,
Sorry.
you moved on, I'm sorry.
No, my apologies.
What was your question? I was on 3432.
Oh, I'm sorry. I'm
I was
sorry.
searching, I was scanning.
No, let me,
Okay.
it's in policy 2400.
Yep.
The first paragraph, the last sentence,
Mhm.
where I wanted to inject the word all in front of students.
Fine.
I mean, I'm just, you know,
I mean,
sort
to
of,
me, that's overkill. Once again, I don't think, I mean, students are students. I mean, I don't know.
but I was trying to support our equity work, you know, that all does mean all, and not when it's convenient, you know, so I'm not tied to it, but I just thought it was an important piece. So it's being tabled, so maybe we can just talk about that with Patrice and Mr. Johnson, you know, at some other point.
Okay. We will wait on that. Policy 2410 revises language throughout for clarity. I took a good long look at it. Didn't really see anything that
2410?
jumped out. Yep, on 2410. Does anybody have anything on this clarifying language? I actually thought it was excellent.
Yes, and that is, this was the policy I was getting to when, in the letter A, under the last paragraph that is inserted, where it was talking about proposals to adopt, revise, or rescind policies may be added to the agenda in accordance with our board policy 2330, which was the agenda which we just talked about. And and that's where I had a note to myself on old business versus new business versus information versus action items. So we don't have to be so meticulous about what category we put it under. So this question, I think, may be for Colin. It's in letter B in the second paragraph when it's talking about a third reading of the board. I am not familiar with the third reading of the board, so I wanted to just get clarification on when we might have to use that.
Can you scroll down a little bit? I can't see that language.
Oh yeah, keep going. It's in B, Kim, the second paragraph. Right there, kind of right in the middle column.
Colin, my understanding of this was just that if the board desired a third reading because there was substantial debate or substantial curiosity, that it could do that.
So this is, I think what this means, just to clarify, so this is not talking about amending a prior existing policy. This is about for a new policy. If it's been through, it's going through second reading, and then at that meeting, the board wants to amend it, that does not require yet another reading.
So that we could basically amend it from the dais during second reading talks. Is that what that?
Right.
Or
That's
we
right.
could opt to send it back.
That's right. You could choose to, I mean, so it gives you the flexibility if you want to put it off for another meeting to allow the public time to comment and consider. You can do that, but you're not required to.
Okay. Just didn't, never heard of third reading, so I wanted to just ask you about that. And then I wanted to call our attention to letter C, because this came up in a previous conversation, Nelson, that you had just brought up, where it says the board may revise and rescind an existing board policy only by majority vote. If a proposal to revise or rescind a policy is included in the published meeting agenda, the board may take action on that proposal at that board meeting. And so what it is essentially telling us that if we...
Can you finish reading that?
Okay. If, however, a proposal to revise or rescind a policy is presented at the board meeting as an addendum to the published agenda, then the board will not take action on that until the subsequent meeting.
Right.
So, and correct me if I'm wrong, this is where I'm taking that with revisions to our policies, we do not have to go through the first and second reading process. We can just take it from the policy straight to the board meeting, and then the full board can vote.
No, that's not how I'm reading that at all. What I'm reading there, if a proposal to revise or rescind a policy is presented, and Mr. Scheib, you know we've had a lot of these on our board. We've had board meetings where we spend about 25 minutes trying to come up with policy language from the dais. It would seem that that would be disallowed under new policy 2410, that we couldn't just change it, because I know people say that often, we can just change it right now. That would seem to suggest that if we do it on a whim, if it's not part of the agenda, if it's added in, then we can't just change it. We have to wait until a subsequent meeting.
So the language here prohibits you from adding a policy to the agenda at a meeting, while you're at the meeting, and then making that change effective immediately.
Right.
I think that now the question that I think this leaves open is if you have a policy, say 2330 or any other policy on your agenda for a meeting for amendment, and then you get into that debate and the specific language is altered, I don't know that this would necessarily prohibit that from becoming effective immediately. Does that make sense? I think what this what this seems to prohibit is just adding a policy on the agenda that was previously not on the agenda and making that effective immediately. But if the policy was noticed for a possible revision, if the change to the language is made is not exactly as proposed from policy committee or otherwise, I think you might still be able to have that be effective immediately.
That's how I read that.
Okay, so this is what I want to clarify, so that board chairs know how to put policy amendments on the agenda. Are we required to have a first and second reading with policies that are being amended, just like we have to have a first and second reading for policies that are new? That is the point that I want to see if the wording does that, or is that something that we just decide on the fly at any meeting?
No, so for amending a policy, if it's put on the agenda, then you don't have to have a first and second reading. You can go ahead and amend it, revise it at that meeting.
Okay, so we don't have to have first and second readings. We've been doing that, but we don't have to. Okay, so I just wanted us all to be, want us all to be clear that we can take it straight from the policy as an amendment to the full board as an agenda item, and we can vote on it. We've received several conversations from the community that is annoyed that we didn't have a first and second reading on certain policies. So I just want to make sure that everybody knows that we are not breaking any rules, and we're not breaking our own policy, and we're not breaking state statute.
Mr. Chair, just a couple things. Can somebody refresh my memory, the difference between the green section and the red section? Obviously, the red section is new, but what is the green? Why do we have a section in green at the top of 2410?
Got me.
And
But it looks like it's just moved from C
Yes.
under to A. I think it's just
Okay.
where we move
Okay.
language, that's all.
Well, I think that, first off, I'd like to say that I do agree with that green section for sure. And since we have the board chair here, I'd like to get further, because I think we've all heard time and time again that, oh, I officially, I'm a citizen of New Hanover County, and I would like this added. So can you define for us exactly the way a person in the second paragraph, any board member, individual, group of citizens may initiate proposals? How would a, Mr. Smith or Mr. Jones or Mrs. Smith or Mrs. Jones initiate said policy proposal?
And Colin, you may be able to help more quickly than me, but we do have another policy on that in the 2000 series where it talks about how community members can get things on the agenda. On our agenda as policy committee, it's pretty specific. I don't know, I can't quote it verbatim, but it basically, they have to send a note to the superintendent and the board chair requesting this, and with a lot of other different stipulations. So we do have another policy around that, and I apologize, I don't have it off the top of my head.
Well, I think we've all heard, and as Mr. Boyer had mentioned before, the need for more transparency, and I would agree with that. I think we just need to have that because we've had a lot of people try to do it and not be successful because they haven't fulfilled exactly what needed to happen. So I was hoping to have a little more discussion since this policy was up about that and help, the citizens that are watching be able to understand that policy and that
I would recommend, and I'd be happy to second it if you would like to put it on, a information item at the next board meeting talking about how that happens. I don't think it's a good idea to do it
Okay.
when,
All right.
I don't know, how many people we got watching our policy committee meetings?
A
I
lot
think
of
it'd be
people
better to
watch
watch.
it after the fact.
Yeah, so
They
why
may not be
why don't we just have an information item added to the
Excellent
monthly
idea.
agenda?
I would so move.
Colin's got a comment.
Oh. Sir?
Did you have a comment, Colin? I heard a blip.
Yes, I just wanted to be clear that there's a difference between the policy development and getting an item on the agenda. And so this policy talks about how a individual, group of citizens, student or employee can initiate a proposal for a new policy or a change to an existing policy. And it states that the way to do that is to refer the suggestion to the superintendent or designee. And so basically, I just read that to mean that one of those individuals that wants to make a change to a policy or initiate a new policy could send that to the superintendent by email, letter, or any other communication, and but there's no guarantee that that's going to be acted on. There's no guarantee that that's going to get on the agenda.
Does it not say, though, the superintendent or designee shall submit proposals to the board policy committee? So to me, that reads that they would, that they would do the study and then they would, I don't know, that's why I read it.
So it would be, you are correct, it would be submitted to the board policy committee, but I don't think that binds the policy committee to act on it necessarily.
Fair enough. But I would, again, I seconded you for,
Yep, let's,
I think that'd be a great thing
let's
so
do
that it is transparent. Thank you.
let's
So-
have to-
To go on the October agenda.
yeah, I'll send you an email.
So are you talking about policy development or
Yeah.
getting an item on the agenda?
Just an information item on the agenda.
For which-
For
explaining-
which?
Just explaining how citizens can get things on the agenda.
But I
How
think
they
Pete's
initiate that
was
process.
not about on the agenda. Pete's was initiating a new policy, if I understood correctly.
Well, but I think in the big picture, I think Mr. Boyer is, what we've heard, at least what I've heard, I can't say what we've heard, is I'd like to get something on the agenda. So I think that is actually the more pertinent
Relevant.
question. So thank you.
All right, we'll discuss that.
Yeah,
later date.
we'll put
Okay,
something on.
thank
Because
you.
they're two specific things.
Mhm.
With
Well, maybe
regards,
both.
with regards to policy 2410, is there any other change? Can we make any changes? Doesn't look like it. is there anything else that we need to discuss before we move it on for amendment? Okay, then, policy 2410 will go on for amendment without changes. Our next policy to be discussed is policy 20, I'm sorry, Ms. Farnham, did you have anything on 2400? Or on 3430?
No, not yet.
Okay. That's fine. Our next policy up for discussion is policy 2600, consultants to the board. I was fine here. The only change was a reference in the body of the policy, and then it's cross-reference to policy 6450, purchase of services, but that was it.
I'm good.
I'm good with it.
Move 2600 on to the board for amendment without changes. Our next policy up for discussion is policy 2610, board attorney. It adds optional language regarding circumstance under which staff may consult with the board attorney. I would ask for any objection, if there is any, with regards to that change.
So basically this, as I read it, says that if a senior staff member wants to talk to the board attorney, that they have to go through the superintendent. Is that correct?
That's the way I read this policy.
Okay.
Is that what we're currently doing? Is that,
Thank you. So, just not anyone can contact Superintendent Smith. So each department will, department lead has, or when I say lead, I'm talking about assistant superintendent level, contacts the office and on behalf of their employees, because it says board designee. But not anyone just calls Superintendent Smith without making sure that anyone who is sitting at this table, that the superintendent, not superintendent, but the assistant superintendent level has knowledge of it.
So I don't have any problem with the way it's written, so I guess the only big question is if you do or you do, but Dr. Faust, are you okay with this policy? I'm fine with it.
I'm fine with it.
We will move policy 2610, board attorney, on without further changes for amendments. Next policy up for discussion is policy 3100. And 3100 is reflective, I believe, of a new reality with regards to curriculum development. There's substantive changes that I noticed. But it adds that in addition to using statewide instructional standards, curriculum must be developed using any other legally required resources in recognition of new legal requirements that literacy curriculum and instruction must adhere to the statewide literacy instruction standards to be developed by the State Board of Education, and the new model literacy implementation plan to be developed by the North Carolina Department of Public Instruction. The only changes here are, as I said, reflective of that new legal reality. Are there any questions?
I do have one, Mr. Chair.
Mr. Baltimore?
I think of our neighbor, Brunswick County, that has a policy that actually is exactly the opposite of this in my reading, that says that they will not follow the state board policy per se. So with that in mind, I don't know that we need to say that, you know, and I think, again, I hate to keep calling on Mr. Shive, but are we legally bound to do whatever the state board says? Or can we do as Brunswick County has done and have a policy that says that there may be a section that we do not follow?
and
Our
could you be more
state
specific? Are you
authority-
talking about their 8710 about not teaching CRT?
Well, that's exactly what I'm talking about.
Yeah, I think we should be specific when you're saying it.
Our power is enshrined in the North Carolina State Constitution. It comes from them. It emanates from the state constitution. Without the state constitution, this board has no authority. And I don't think I would ever risk a superintendent's license by saying, yeah, we'll just do what we want to do. We're not going to follow the state standards.
Well, I'm just asking, you know, are we legally bound, as it says here, to follow the state curriculum per se, or is there some flexibility? You know, I guess my question is, how is Brunswick County saying that we're going to not teach part of it?
I have not reviewed Brunswick County's policy, but I'm happy to do that, provide advice to the board at the next meeting. I wasn't aware of it, haven't seen that yet.
There is another policy that we read that talks about getting a waiver to not follow some of these kind of things. my understanding that any school or a district can ask for a waiver, but we have to,
Before we ask for any of that,
yeah.
can anyone provide evidence that we've been teaching CRT?
Well,
Let's start there.
Yeah, no, I understand that.
But is there anywhere where there are artifacts that show that we have been teaching any of those?
Well, again, as I brought up over a year ago, some of the words, Dr. Smith was doing a presentation, and I brought up, and I don't have that in front of me right now, but some of the words that are in the glossary are words that have been used, and in many people's minds, I'll say it that way, in many people's minds are reflective of CRT. So that would be my first question. My second question is, I'm sure we've all seen the Montgomery County board policy that they just passed, talking about other things that are pushed out by our state government. And you know, so I'm raising questions because, again, I think we should be totally transparent. And so I guess back to my original question: are we legally bound to do exactly the whole curriculum as presented by the State Board of Education, Mr. Shive?
So I don't know the answer to that question, and I'm happy to look into it. And if the curriculum specialists that are in the meeting can weigh in on that, I defer to them, but otherwise I'd have to research that.
Okay, thank you.
So Colin, I just looked it up real quick. I was wrong in my quoting. It's policy 7720, and it does say, and that is employee political activities. I don't know how they put it in there, but it just says, further, this policy shall ensure that social theories of any kind, Holocaust denial theory, 9/11 theory, critical race theory, are not presented to students unless approved by the Brunswick County Board of Education. It is the responsibility of the board to ensure that curricular standards are taught using well-documented factual resources and not opinion or conjecture. So they are not saying, in my opinion, that we can't teach it. They are just saying that the Board of Education will want to look at what the curriculum committee, this is my opinion, what the curriculum committee comes up with. And that is something I feel like we're doing right now. So with Dr. Faison not being here to talk about that, but we've had several conversations about that. So they don't even have that in the curriculum policy. They have it in a political activities policy, which we're not talking about educating our kids in a political arena. So that's...
Sorry, Ms. Craybill, to interrupt. So, yeah, I think that that is also different than saying that the board will follow state Board of Education standards, except those items that you listed off, I don't think would be part of the State Board of Education standards.
Well, I was going to say that doesn't in any way say that we're going to break state law. I mean, I don't think that any of those theories are taught, and personally, I will publicly disassociate myself with any policy that lists critical race theory with Holocaust denial theory and 9/11 truthers. We can have differences of opinion, but those are two very, very different things. One is actually an academic standard at the college level, and the other, I would hope, would not appear in any college.
Well, also too, we don't have to copy what other boards do. We need to figure out what is right for New Hanover County schools, and we need to follow all of our rules and the state legislation. So if they want to go off on a different tangent, any district in the state is welcome to do it. But anyway, I don't think that, to me personally, I don't think that's applicable to this policy, because the curriculum development team brings their information to us and we approve it.
Can I add one thing? There may be sections, I know for special education specifically, and some of our social emotional learning pieces where we have to document our compliance with state board policy and with general statute. And for example, for all services for students with IEPs, and it's not just the IEP service, it's all service for those, before we can even write our funding grant, which is not a competitive grant, it's basically you'll get it when we approve it. We have to do an acknowledgement at the very beginning of that to say we comply with all policies that are adopted by the state board or under federal regulations, or we don't get our funding. So if any of our teaching requirements are included in that, we could be forfeiting funding if we waive or try to waive certain curriculum components. Just offering that out.
And for what it's worth, I just looked up the Brunswick County Board of Education policy, curriculum development 3100, and it reads exactly as this policy. They have the same policy as this.
Thank you.
Thank you.
Alright.
So I did have a comment on this, other than that. It's again in letter A, the first, well, it's only one the first paragraph, the last sentence, where it says the committee must seek input from parents, the community, and experts in order to make fully informed decisions. So I wanted to make sure that we put students in there, if we are so inclined. If you remember reading in the policy, the proposed policy 4004, the students are asking to be a member of all of our board committees and our board advisories, and the curriculum committee is a board advisory. And so I am suggesting that we put input from parents, students, the communities, and experts, if we're so inclined.
Bless you.
I'm fine with that.
I'm fine with that.
Okay.
All right.
Colin,
so-
that's okay, right?
Yes.
Okay.
So we
So
have,
that would go the upper right in the policies with the
yeah, I
revision.
got them all mixed up. I'll have to read off
Yeah,
yours.
okay.
I don't know. Yes. 3100 with changes. Okay.
Oh, and then, yeah, to your point too, down there in letter B, second paragraph about halfway down, it says, after being approved by the curriculum committee, the proposal must be submitted to the board for approval as part of the school improvement plan process. So if schools are doing modifications, then they have to request that they can modify, and the superintendent approves, and then if they approve, he sends it to the board and we approve. So.
All right, moving on, policy 3102, online instruction, nothing substantive here, just changes guidance counselor to school counselor and is reflective of state law.
So two comments. In letter A, 1, 2, 3, third paragraph, that it says, a student with the principal, this first sentence, a student with the principal's prior approval may enroll in an online course with the assistance from the school's e-learning advisor. The principal at each high school shall designate an e-learning advisor who will be responsible for coordinating. And later on down, it says that middle school students are allowed to take these online classes in middle school. So do we need to have, does the principal need to designate an e-learning advisor at the middle schools?
They
Huh?
are, they're there.
All right, so then should we write that in there, the principal at each middle and high school?
Well, it's actually through the curriculum department, they have an individual that's already there, so it's not like the principal does it. The district already has individuals that take care of the online programs for middle school students.
Okay, so, but this policy that we already have, we've adopted, says that the principal at each high school shall designate. So I'm just making sure we have middle school covered in there.
Yes, that's what I'm saying.
Okay.
We do.
But do we need to write that, or
I don't think, because there are middle schoolers who take was it North Carolina, oh my gosh.
NCVPS?
NCVPS.
Yes, yeah.
They do that now, and so it's already aligned, and we have someone who is over that at the, they serve at the district, well, say they even serve at the district level, they are like the lead, for that, but they visit all of the schools, make sure that there's compliance, that they're on, they send out, reports to parents. They are the liaison between the, teacher, if it's a high school teacher who is teaching the class or oversees the class, they serve as that liaison. That's already taken place.
Okay, so then should our policy read, e-learning advisors will be responsible for coordinating blah, blah, blah?
Well, the principal does make sure through scheduling that it happens. I think we're going too deep, and then I think it will tie us, but I'm just saying this already happens.
Okay. Okay, so middle school principal,
So, you know, I think, you're at the line where it says enrollments at other schools? Is
no,
that what
I'm
you're-
in letter, the paragraph 3 in letter A, the second sentence.
The principal at each high school should. But I was looking, so for as far as middle schools are concerned, what Dr. Faust is saying is correct. We have a central office person that kind of handles that for us, so that I think it's kind of covered in that next sentence.
In the next,
Enrollments
okay,
at other schools will be handled by the school system's online education supervisor. So we have a person, and so what I do, and what most schools do, is we designate an AP that communicates with that online supervisor if we have any students that are taking advantage of those resources, and they kind of work together to make sure they have what they need.
okay, that makes sense. I didn't read burnout, thank you, sorry. Sorry.
Anything else on
I can't
3102?
let that one slide.
I know, you're fine, I'm good. I will take that, not a big deal.
Not only as a superintendent, but I do know what's going on in the district. And I want y'all to start taking my word for what's going on in the district.
Got it.
Yes.
Duly noted.
Anything for 3102?
Yeah,
Anything
in
else?
letter B, there's a misspelling, in line number 2, where temporary should be temporarily, it just wasn't translated properly from the notes.
And Dr. Faison is logging on.
Okay,
She's getting off of the bus.
Change temporary to temporary.
to temporarily, that's just a typo.
All right, anything else? Do we have to call that a change? Probably not.
No, that's just, yeah,
Just a typo.
yeah.
Okay, we will move 3102, online instruction, on for first reading. Or on for amendment, I apologize. Our next policy for discussion is going to be policy 3300. Wow, school calendar and time for learning. Wow, how ironic. The calendar for the policy committee meets the calendar for the calendar. I did have a change here. The school calendar committee has not historically been chaired by a board member. I don't know if that was in policy or not, but the subject matter expert is the chair of the calendar committee, and with good reason. I mean, board members, some of our current board, struggle with the complexities of our state calendar law, so it doesn't make a lot of sense for a board member to chair that committee. I certainly enjoy opening it and hearing myself talk, but I like the listening part a lot better. Does anybody have a problem with making that change?
No, because in fact, this policy is in direct conflict with policy 2230, which we've been trying to amend for a year, where we have in there that the calendar committee is a board advisory committee chaired by a school system subject matter expert, with a board member being on it. So we need to change one or the other. And so I agree with you that in letter B, the committee will be chaired by the superintendent or designee, and must include one board member. So just to swap those words.
Yeah.
My only question would be, in our current situation, person that was the chair, as it's up for discussion, is no longer a school system employee. So I'm fine either way, but that would be my only reason that I would
Dr.
say.
Faison is now
I understand she is now, but she can't speak to what happened last year. Where
this
you were.
doesn't have
But
anything to
this
do
isn't
with that
speaking to last year, this is speaking to the policy.
Well, I understand, but if you could listen to what I'm saying, is in this unique situation, board members have asked, I know Mr. McManus has asked, to speak to the chair of the committee. The chair of the committee is no longer employed by New Hanover County Schools. So if the chair was in fact a board member, then that person could talk with their colleagues. In your case,
Mr. Wildeboy, haven't I been talking with you guys about the calendar?
Well, I
As the
know
liaison?
you have somewhat, but there's been several times you said, I really don't know, I wasn't the chair. I mean, so that.
I'm not
that's
the
my-
chair, I'm the
I
liaison.
understand.
And I never said I don't know.
I disagree with that, but,
I've never said I don't know.
okay.
So,
Unless I don't.
Well, okay, I'd like to say I'm
Dr.
fine either way.
Sorry, Dr. Faison has joined us. Do you want to address your question to Dr. Faison, Mr. Wildebohr?
I don't know that you could answer that. I mean, because, again, as I say, I don't think Dr. Faison has any knowledge of the goings-on of last year's calendar committee. I mean, if you do, that'd be great, but I know Mr. McManus has asked repeatedly to hear from those folks that are on the committee. And again, the person who was the chair, and if we follow the policy as Mr. Bollier has asked for it to be changed, then we would, we may have that situation in the future. But anyway,
Well,
like I
Mr.
said, I'm fine
Wildebohr,
either
to
way.
that
I'm
point,
fine either way.
we have conflicting policies right now. So following the current policy of 2330 board committees, we have the calendar committee listed as an advisory committee to the board that is chaired by a school district employee. Then in policy 3300, we have a policy that says the committee will be chaired by the school board. So that is what we've been trying to work on with policy, with the board committee 2230 for a long time, is to have our things match up. And this is a clear one, and I will take responsibility that I was not involved in this policy when it was adopted on 12/8/20. So when I started reading this one, looking at just the changes that they said, it says minor changes, and I looked at it and went, holy moly, this is not a minor change. We have a conflict with board policy. So all we're doing with this policy, 3300, is we are deciding to make it match 2230, or then we will have to go back and change policy 2230 before we amend it to make it match 3300. So that's what this, to me, is all about. Not what has happened in the past. What do we want to do?
And let's ask Dr. Faison, since we do have her on the call now. Would you prefer to chair the calendar committee with a board member on it, or would you prefer for a board member to chair it with you on it?
Can you guys hear me?
Yes, ma'am.
Yeah.
Oh, okay, I'm sorry. I was asked to do something on my mic. Could you repeat the question, Mr. Wildebohr?
Absolutely. Thank you for being here, first off, Dr. Faison. I just asked for your preference. Would you prefer to chair the calendar committee and to have a member of the board on it, or would you prefer for the Board of Education member to chair it with you on it, or don't you really care?
Well, first, of course, I'll do whatever the will of the board is. I will say, I think it is common practice for a district person to chair the committee. I do work with the team and try to bring the instructional knowledge and share those aspects of the committee. I think the board, I love the fact that the board member is on the committee. I also actually love this year that we have 2 board members who joined the committee. So, of course, I'll do whatever the will of the board is, but I think that if we look at, talking to my colleagues, it's normally someone in my role or someone at the district level that chairs.
Okay.
But of course, I'll do whatever the will of the board is.
Absolutely. Well, thank you very much, and I'm fine with that.
Sorry. Dr. Lawrence had something. I bet Dr. Faust would like to weigh in too. Okay. Okay, you'll yield, okay.
Thank you. You'll be sorry you did that. Just 2 comments. One, I would be curious if that comes into conflict at all with Board Policy 1010, which says that the goal of the board is to establish general policies in keeping with the needs of the community, requirements by law, that sort of thing. Would this sort of supersede that because it's different from a policy generating sort of role? The other concern I would have, and the reason why I have to be careful when I join the calendar committee or if I go to meetings, is that you guys are the ultimate employers of the people who will be making the policy committee or the calendar, and that could cause a rift, a conflict of interest. I would be concerned that that would be difficult for a possibility for some employees.
Having a board member be the chair of that,
the committee.
yes.
I just think that's something that should be reflected upon.
Fair enough.
Yeah, and I also just wanted to add, we are not the subject matter experts, you know, in the school district. I mean, we hire Dr. Faust and his team, essentially, you know, through him, you know, to be aware of all of the laws and the inner workings of the school district. We don't know all the inner workings, so,
Ms. Craybill?
Yeah, go ahead.
I think that's a very good point that I do want to make sure that I do highlight. That I have learned a lot of calendar law doing this, and you really need to, you know, I present it and try to make sure make sure the committee understands the calendar law, but the person who's chairing that calendar committee is responsible to make sure we follow those state guidelines and understands the calendar law and communicates and asks those questions. So I think that's a good.
Thank you.
Thank you,
Well, I'm
Dr. Faison. I'll just say, you know, I don't comment much on process, but the calendar does not begin with the first calendar committee meeting. That's not how it works. The administration assesses the needs of our students, looks at the calendar law, and brings forward 1, 2, 3, 4, 5 suggestions, and then the calendar committee discusses it, makes small corrections where we can, makes small adjustments where necessary, and then that calendar goes back. It's not as if the calendar committee process starts saying, all right, everybody show of hands, what day, what time, what place, and then we build off of that. That would be anarchy. So I don't comment much on the process, but I just want to make that clear.
And again, with Dr. Faison's input, I'm fine with changing it to a central office, however we want to say that, a senior staff member, superintendent or designee, I guess would be fine.
Okay, so are there any other
Yes.
changes?
In that same paragraph where it talks about the membership of the committee, we need to add student. So that sentence, the committee will be chaired by the superintendent or designee and must include at least one board member, a teacher, parent, and principal and I want to add in a student, maybe not from each level, but at least high school, to weigh in on that. That is, it's consistent with policy 4004 that the students
Yeah,
have
that's
asked for. Okay, and then I think then we should add in.
Where are you?
I'm getting there. The cross-reference is to add policy 2230 board committees so that we make sure that when we're making changes to this, that we might have to make changes to that.
Fine. Add that cross-reference.
Sounds good.
Add students. Those changes being made, are there any further discussions about policy 3300? Okay, move that on to the board for amendment. The next policy up for discussion.
That will be with changes, correct?
That would be with changes, yes, sir. Would be policy 3410, testing and assessment program. In section A, it adds the obligation to provide interventions to reflect new state literacy intervention requirements and updates those legal references. This is a state requirement change. I don't see anything substantive here. Does any board member or senior staff expert have anything to add?
I think it's needed. I think the interventions need to be put in there, so I think it's excellent.
Ms. Crable?
No, I'm good.
Senior staff? Excellent. Move policy 3410 on to the board for amendment with no changes. The next policy up for discussion will be policy 3420. Again, this is mostly state law stuff, but I didn't think it was lengthy enough to allow for some discussion. Subject F is updated to address all literacy interventions that will be required beginning with the 22-23 school year, modified information about reading camps, et cetera, et cetera. Let me ask, because we are coming up on time, does anybody have anything on this policy to discuss in depth?
The only question I had was, it's not about the policy, I just wanted to, it sort of is. In letter L, where it says the reporting requirements, the superintendent's report to the board, is the superintendent's report to the board with respect to that, is it this report that you gave us?
So that would be one, so we do a couple reports. Every October, since I've been here, accountability and research will do a full-blown out presentation to the board.
Okay.
And then throughout, that may not just be this one, but we'll have AIG reports. So you'll get updates, full-blown out updates. But yes, that's one portion
Okay.
of it. And then, of course, you get graduation updates, you get attendance updates.
Okay, so I just wanted to make sure that other folks were clear that that's what I thought we were referring to. And then in letter L, also number 3, Mr. Smith, the publication on the school system's website. So all the stuff that, the reports that Dr. Faust was mentioning, those, how would they find those on the website? Are they in a special area?
So currently at each school, for last year, they had their report card at each school.
Okay.
So that is on the school's website.
Okay, and that's just for people who are watching, so they know how to do that.
And we'll release the new one. I don't think we've released the new one yet. That's usually after the state school board has to release all the report cards, and then we will typically give the board the full blown out
Okay.
presentation, and then the schools will update theirs on their website.
Okay, thank you.
Okay, Mr. Woodward, did you have any questions on student promotion and accountability?
I do not.
I did not either. We did want to allow some time for discussion. Ms.
Sorry, I
Vaughn?
have a quick question. Letter F, the title says literary intervention. I think that needs to be literacy.
Thank you, Ms. Warren. I always miss them.
So are the literary plans, like the, where we called it the individual reading plans, are those all included in part of the school improvement team? I mean, school improvement plan as well somewhere?
Not necessarily. Dr. Faison.
Well, we actually have a district literacy plan, and our literacy plans are posted. They have to be posted on our website. So we have that, and in each school improvement plan, you do have areas where we address literacy and interventions. But the state requires every district to have a literacy plan. So we have that plan, and that plan is posted and is on our website.
And so each school would refer to the literacy plan in their school improvement
Yes.
plan on how they're going to address it? Is that kind of how that works-ish? Okay.
Yeah, basically, the district plan is the, where we start. So then each school actually narrows that down and takes pieces and works with their data, their students, and develops their school improvement plan, which in turn addresses literacy.
Okay, thank you.
Huh?
We all set, 3420? Okay, we are coming up at the end of time. We're going to go ahead and make 3420 without changes onto the board for amendment, our last policy, so we can begin to wrap up. We did a lot of good work today, and I'm appreciative of everybody's time, so I want to maintain that respect. You'll probably get me if I mess up, because I was all over that. So I just want to say before we vote, that the individual policies were already voted on. This is just a reflection of the will of the policy committee. So when I'm asking to move these policies forward, I'm asking because some we just sort of agreed to and we get to later, but this is just a reflection of the will of the committee. So, okay, the policies that are moving before the board for amendment without changes.
Without changes.
Policy or regulation 1725-4075-729, 7236.
Dash R.
Dash R. Policy 1710, policy 2121, policy 2210, policy 2302, policy 2410, policy 2600, policy 2610, policy 3410, and policy 3420.
3410, I don't have that one on here at all.
And I have 3102.
3410 is testing and assessment programs.
What about 3102?
3102 is without changes, or we make a change?
Yeah, I have that without changes.
Without
Okay.
changes.
And
What was that
policy-
last one? 31 what? I missed that somehow.
3102,
No, the other one you just said.
3410,
Mhm.
testing and assessment program.
Okay, sorry, I didn't write that down.
Yeah.
Are we good?
Yep,
Okay, the policies that are moving forward with changes are policy 2120, policy 3100, policy 3300,
okay, so I have in
and
there.
policy 1310.
Yep, and then 2330.
2330, thank you. Told you I was all messed up. All right,
And then policies to be held in committee, 2400.
yes, policies to be held in committee. Do I hear a motion to move all of those policies, either amended or either changed or unchanged, forward to the board for amendment consideration?
So moved.
There's a motion, is there a second? I will second. All those in favor say aye.
Aye.
Any opposed? Motion is agreed to, and policies will be moved forward to the board for full consideration. The last item on our agenda is everybody's favorite, the item to adjourn.
So moved.
There's a motion, is there a second? Motion is second. Hearing no objection, we are adjourned.